Oh, there it is. Okay, it's up in the right-hand corner. Very good. All right. Well, now that we are online, again, my name is Charles Pratt, and I'm the judge that's been assigned to preside over this trial in the high school mock trial competition. Is the prosecution ready to proceed?
Yes, Your Honor.
Is the defense ready to proceed?
Yes, Your Honor.
All right. Normally, in a non-virtual environment, I have you provide your rosters to the scoring panelists, but let's start with the prosecution, and if you can introduce yourself and your team members so that the panelists will know who you are.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Katerina Zhao, and I will be performing the direct of Alex Cifuentes and the cross-examination of Taylor Perkins, as well as delivering the closing statement. May my co-counsel introduce themselves?
They may.
Good morning, Your Honor, the jury, and my opposing counsel. My name is Caitlin Mon, and I will be performing the opening statement, directing Kyle Cusack, and crossing Blake Van Owen.
Good morning, Your Honor. My name is Marcus Walker. I will be directing Jordan Markowitz as well as crossing Avery Becker.
All right, thank you.
May our witnesses introduce themselves?
That would be great. Thank you.
Good morning, Your Honor. My name is Adam Smith, and I will be portraying the witness, Alex Cifuentes.
Good morning, Your Honor. My name is Damilola Adekola, and I will be portraying Kyle Cusack.
Good morning, Your Honor. My name is Sana Sodi, and I will be portraying Detective Jordan Markowitz.
All right. And who is your timekeeper?
Our timekeeper is Cameron Grosshams.
Okay, I see Cameron down there at the bottom. Okay, very good. All right, from the defense?
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Brakeen Mahoney, and I will be doing the defense opening statement, directing Professor Blake Van Owen, and crossing Alex Cifuentes.
Good morning, Your Honor. My name is Emily Simon. I'm an attorney for the defense, and I will be doing the direct of Taylor Perkins, along with the cross-examination of Kyle Cusack.
Good morning, Your Honor. My name is Sadie Fitzpatrick, and I will be doing the direct of Avery Becker, the cross of Detective Markowitz, and a defense closing statement.
And your witnesses?
Good morning, Your Honor. I am Kendall Adams, and I am Blake Van Owen.
Good morning, Your Honor. My name is Sevilla Montoya, and I am Taylor Perkins.
Good morning, Your Honor. My name is Bradley Calkins, and I am Avery Becker.
Okay, and your timekeeper?
Good morning, Your Honor. I'm Lee Waxter, and I'm going to be the timekeeper for Team B.
Very good, thank you. All right, the video is running, and let's see. I'm to inform the teams and everybody that might be listening that the Colorado Bar Association is recording this, or at least it's live streaming and may be recorded. It may be used for informational purposes. I don't believe we have anybody in the gallery that I need to talk to. I'm to remind the teams that there are no recesses are allowed with the exception of those granted for a health emergency. And even then, we try to avoid them between the end of a witness examination and the beginning of the cross-examination. The scoring panelists have already indicated that they do not know any of the folks and we don't have any conflicts. Need to remind the teams and the coaches that any disputes arising out of this competition must be recorded and reported in accordance with the competition rules. Remind the teams that the compliance with the time requirements will be considered by the scoring the individual performances. Now I need the parties, first the team members, to raise your right hands for me. The attorneys, please. are the team members here? Yeah. Do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? If so, say you will. You will?
I will.
I will.
Well,
I do.
Okay, great. Now, if the witnesses can raise their right hands. Do you promise that the testimony you're about to give will faithfully and truthfully conform to the witness statements and that you will not add facts or opinions that are not contained in the case problems and that you will follow the rules and procedures of the mock trial competition?
I will.
I do.
I do.
We don't have any gallery members that I can see, but I will remind anybody who's watching that you do, even before and after the competitions, please represent yourselves as positive role models that exemplify the ethical and professional sportsmanship of the mock trial rounds. Now, would the scoring panelists raise your right hands? Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts and procedures and rules of the mock trial competition?
I do. I will. I will.
Thank you all.
Your Honor, one question. What is the letter of the prosecution team?
Yes, we covered that. We covered that before you guys got here. I apologize.
I was late to it. I'm sorry.
These are teams L and B. B as in boy.
Thanks, Your Honor.
And team L is the prosecution, correct? Okay, I'm getting positive
Yes.
nods. All right. All right. Any preliminary matters that the parties want to bring up before we start?
Yes, Your Honor.
You may proceed.
For purposes of Zoom, we ask to remain seating during openings, closings, as well as directs and crosses.
That's fine. I appreciate that. You bringing that to my attention. That makes a lot of sense. Any other preliminary matters?
Yes, Your Honor. We ask to reserve any remaining time for rebuttal.
Without further request, just make it happen automatically.
Yes, Your Honor.
Any objection to proceeding in that fashion from the defense?
No objections, Your Honor.
All right, very good. That's how we'll proceed. Any further preliminary matters?
Yes, Your Honor. We ask that for permission to share exhibits through Zoom share for identification purposes.
Okay, when you say Zoom share, you want to just share screen?
Yes, Your Honor.
Okay, any objection to proceeding in that fashion?
No objections, Your Honor.
Okay, very good. All right, any other preliminary matters?
We ask to screen share our stipulation facts.
Any objection to proceeding in that fashion?
No objections, Your Honor.
Okay, you may do that at the beginning of the trial or whenever you want to do that. Okay, any other preliminary matters?
No, Your Honor. Thank you.
Any preliminary matters from the defense?
No, Your Honor. The defense is ready to proceed to trial.
Very good. All right, is the prosecution ready for opening statements?
Yes, Your Honor.
All right, you may proceed.
Okay, thank you, Your Honor. How far would you go to get revenge? Would you ruin someone's car? Would you break into their house? If the thing you loved, the thing you excelled at, was taken from your grasp, would you be willing to kill for it? Ladies and gentlemen of the jury, on March 6, 2020, this is exactly what happened when the disgraced Avery Becker murdered their past coach of the high school mock trial team, Mackenzie Brackman, in his own home. Brackman, a valued member of the community, coach on the high school mock trial team, and respected lawyer, had kicked Becker off of the mock trial team for their repeated laziness, disrespect, and impulsive actions. And throughout this case, you will see the tale of the defendant, Avery Becker, a person who responds to the consequences of their irresponsible mistakes with destruction. First, by vandalizing the victim's car, then planning to trash the victim's house, and ending with the victim lying in a pool of his own blood. This has led to Becker being charged with 3 crimes: first-degree murder, second-degree burglary of a dwelling, and criminal mischief. Breaking down the severity of these crimes, murder in this case is defined as committing second-degree burglary, and in the course of that crime, the death of a person is caused. Burglary is defined as knowingly and unlawfully entering a dwelling with the intent to commit the crime of criminal mischief against another person or property, and criminal mischief being defined as knowingly damaging the real or personal property of another person. The prosecution recognizes the burden of proof that falls upon us, and we gladly accept this responsibility. We need to prove that we have the right person, and that's exactly what we'll do. The defendant's friend, Alex Cifuentes, will first detail the contentious relationship between the victim and Becker that ends with Avery being demoted and eventually kicked off of the mock trial team, along with Becker's impulsive vandalization of the victim's car and their intention to break into Brackman's house. Their testimony will show the evident motive and intent of the defendant and the precedent of Avery damaging things because of their emotions, specifically the victim's things. They will be followed by crime scene reconstruction officer Kyle Cusack, who has been specializing in the exact crimes the defendant is being charged with for 19 years, who explains how the murder was committed. Respected police officer Detective Markowitz, a detective for 7 years, having been with the Denver Police Department for 13 years, will finish off by telling you about the technological evidence with cell phone screenshots and call detail records that placed Becker at the scene of the crime, and how Mr. Brackman was found left cold, alone, and dead at the crime scene. All of these testimonies will demonstrate how Becker wrote it, knew it, and eventually did it. On the other side, the defense will try to substantiate their claims of innocence with testimonies from the murderer, Avery Becker, the murderer's best friend, Taylor Perkins, and a professor named Blake Van Owen, someone who has only ever testified on the side of defense and who is being paid to find the conclusions that they come to. Avery and Taylor claim that they were together that day, despite having no evidence to back that up and substantial evidence to the contrary found by Detective Markowitz. And the fact that Taylor, being Avery's best friend, wouldn't want Avery to be found guilty. The defense will try to argue that Alex, being Avery's friend, could also be biased in their statement, but this simply doesn't make sense. Alex has nothing to gain by testifying against Avery, whereas Taylor has everything to lose if they don't testify in support of Avery. As the cherry on top of the defense's case, they will attempt to pin this crime on a student named Blair Rollins and use mental gymnastics to link him to the crime through a piece of evidence from 7 years ago, when Blair was 11, a child in middle school. Blair was simply thrown in to distract from the fact that Avery's case is crystal clear. Becker admitted they were going to break into Brackman's house and wrote it. They had a motive and had been aggressive and destructive towards property and knew it. And finally, the evidence will show that Becker's phone was traced to Brackman's house during the time of the murder and did it. Ladies and gentlemen of the jury, you are all that stands between Avery Becker and a cell. To get justice for a man loved by his community, at the end of this trial, the prosecution asks you to come to the verdict of guilty. Thank you.
All right, thank you very much. Does the defense want to present their opening statement at this point?
Yes, Your Honor.
All right, you may proceed.
You're 18 years old. You're a senior in high school, and you're looking forward to your entire future ahead of you. Your mock trial coach is tragically murdered, and you're being accused of the crime. And suddenly, all of your hopes and dreams for the future are threatened of being taken from you. This is the story of Avery Becker. Avery Becker is being accused of the murder of her high school mock trial coach, Mackenzie Brackman. You will see evidence that will show that my client has been wrongfully accused and that the prosecution cut corners in their rush to build a case, did not make reasonable efforts to consider all possible suspects, and rushed the process in concluding that Avery was guilty. In order for the prosecution to prove their case, they're going to have to convince you that this murder was a spontaneous act, not premeditated. Because if you find that this murder was premeditated, even the prosecution would concede that my client is innocent. The prosecution says that Brackman's murder was a heat of the moment act, resulting in death. But in reality, the evidence will show that this was a pre-planned, premeditated murder. And here's why. For one, there was not much blood found at the crime scene. And if there really was a struggle, you would expect to see blood everywhere, resulting from Mr. Brackman and the intruder wrestling for control over the knife. Therefore, the prosecution claims that Brackman and the intruder were standing, as the intruder somehow managed to reach around and stab Brackman from behind. But for an intruder to stab Brackman in a downward angle and still nick Brackman's aorta if they were both standing, the intruder would have to have been a much bigger person than Mr. Brackman. The ring security videos, however, make it clear that the intruder was not that big. And so it makes far more sense for Mr. Brackman to have been sitting with the intruder standing behind him. Also, the knife used to kill Mr. Brackman was an entirely different brand and style from the rest of the knives found in his kitchen, indicating that the intruder came in with the knife and the intent to kill. Now, with regard to Avery's cell phone, there will be witnesses that will explain that Avery lost her phone the day before the murder and was not in possession of it at all the following day. Not only will Avery testify to this, but so will Taylor Perkins, a fellow high school student who was with Avery the entire day of the murder, providing her with a solid alibi. The prosecution is going to show you screenshots of text messages as well that Alex Cifuentes, another high school student, allegedly received from Avery the day of the murder. However, again, in their rush to build a case, the prosecution cut another corner and never obtained the actual phone. They accepted screenshots from a high school student that could easily be doctored. Another reason to doubt the authenticity of these screenshotted texts is that Alex Cifuentes' credibility is in question. Alex has always been jealous of Avery's mock trial talent and wanted her off the team, no matter what it took. Yet another instance of the prosecution's rush to build a case is the fact that the police failed to investigate all possible suspects, including a far more likely suspect, Blair Rollins. We are aware that Avery and Mr. Brackman had several ups and downs in their relationship, but I think we can all agree that a disagreement with your mock trial coach is hardly motive for murder. Blair Rollins, however, had a much stronger motive to kill Brackman. Rollins' father was sentenced to life in prison in the wake of Brackman's deficient representation of him in court. In addition, Blair is of similar build to Avery and could have easily been the intruder seen on the ring footage. The fact that the police settled on Avery as the most likely suspect without even pursuing other possibilities, including Blair, speaks to the rushed nature of the police's entire investigation. Now, during the course of this trial, always bear in mind the burden of proof. The prosecution must prove their case beyond a reasonable doubt. And as I've just explained to you, there are several gaps and shortcomings in the prosecution's case, any one of which creates reasonable doubt. I want to thank you in advance for serving on this jury and for taking your oath as a juror to be fair to my client seriously. At the close of the evidence, I'm going to ask you to return a verdict of not guilty. Please remember what a guilty verdict means to my client, an 18-year-old high school student, and the ramifications that would have on her life. Thank you.
Fine, thank you. Is the prosecution ready to call your first witness?
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand. Good morning. Please state your first name and spell your last for the record.
You're on mute.
Good morning, Your Honor. My name is Alex Cifuentes. My student name is Adam Smith. Sifuentes.
And why are you here today?
I'm here today because Mackenzie Brackman, my beloved mock trial coach, was murdered.
What school do you attend at?
I'm a senior at Colorado High School, or CHS.
Do you know Avery Becker?
Yes, I do.
Can you identify the defendant, Avery Becker? Your Honor, we request for Avery Becker to turn their camera on for identification purposes.
That would be fine. Please do so.
Avery Becker is the girl in the window titled Bricken Mahone with.
Oh, sorry, I'm not Avery Becker. I'm
Sorry.
the defense attorney.
Okay, we need the witness to turn on his or her. Who is playing the witness? There we go.
Can you identify the defendant, Avery Becker?
Avery is the one in the box titled Bradley and with the short blonde hair.
Your Honor, let the record reflect that the defendant, Avery Becker, has been identified.
It'll so reflect.
And how do you know Avery Becker?
We attend the same high school and we're both part of the mock trial team there.
What was your relationship like with Avery Becker?
We were very good friends, basically best friends. Avery was the one who got me into the mock trial team on the first place.
And you stated you worked with Avery on the mock trial team. Did you also practice with them?
Yes, I did. We were teammates.
And did you work with them during competitions?
Of course we did.
How would you describe Avery Becker's work ethic in mock trial?
Avery was very skilled at mock trial, but she never prepared for practice for the tournaments. She would always make things up on the spot, and that was just a constant source of anxiety for the team.
And how would you describe the relationship between you and Mr. Brackman?
I look to Mr. Brackman as a role model. He was an extremely talented litigator and was always finding ways for our team to improve our performance.
How did you work on the mock trial team?
I took mock trial very seriously. I would make drafts of my examinations, openings, and closings on the same day that Mr. Brackman assigned them. I'd go home, create outlines, multiple drafts, and continue to revise and refine those until they were perfect.
And did you see Avery and Mr. Brackman work together?
Yes, all the time.
How would you describe Avery's relationship with Mr. Brackman?
Avery and Mr.
Objection,
Brackman
Your
had...
Honor, hearsay. Lack of foundation, my apologies.
Your Honor, may I?
The foundation objection?
Your Honor, as stated previously before, I asked, did Avery and Mr. Brackman work together, as well as if Alex saw them work on the team together. Therefore, I feel like the foundation has been laid for the question to be answered.
Okay, reply.
I stand on my objection, Your Honor. The witness cannot speak directly to what Avery's relationship was with the victim.
Okay, I'm going to sustain the objection. Next question.
How did you observe the relationship between Avery and Mr. Brackman?
They seem to have a very strained relationship, mostly because of how Avery never really prepared for mock trial, and Mr. Brackman would always get mad and yell at Avery about that, but she always refused to listen to Mr. Brackman's advice.
And you stated that Avery Becker was constantly unprepared. How did Mr. Brackman react to that?
After Avery was late to the meetings one too many times, Mr. Brackman had enough and he demoted her to the B team.
And after that mock trial practice, what happened?
Avery and Mr. Brackman had a conversation. Avery left the conversation angry, and the next thing you know, they wrote "Worst Attorney Award" across the hood of Brackman's car in permanent marker.
What happened after Avery Becker vandalized Mr. Brackman's car?
Avery was kicked off the mock trial team for good. There's a good chance what Avery did was going to make us have to forfeit going to state. It was incredibly unfair to the whole team.
And shortly after that incident, did you have any communication with Avery Becker?
Yes, I did. We're friends after all.
Your Honor, permission for co-counsel to screen share Exhibit 14.
Any objection to Exhibit 14?
No objections to screen sharing, but once offered as admissible evidence, I do have objection.
All right, you may share it.
What is in front of you?
These are text messages me and Avery sent to each other.
And were these text messages delivered to your phone?
Yes, they were.
And who's this conversation between?
This is between me and Avery.
And the text messages on the left in white, who were those sent by?
The text messages on the left were sent by Avery.
And the text messages on the right in green, who were those sent by?
Those were sent by me.
Were these altered in any way before you received them?
Nope, these are the same as the last time I saw them.
Your Honor, I would like to enter Exhibit 14 into evidence.
Any objection?
Yes, Your Honor. Objection. Best evidence, admissibility of duplicates, Rule 1003.
Response?
Your Honor, as the physical phone is not here today, the screenshots have been proven to be authenticated by the questions I have just asked. They haven't been altered in any way before they've been received, as well as Alex has stated who these text messages has been sent by.
Anything further from the defense?
Yes, Your Honor. A duplicate is admissible to the same extent as the original, unless a genuine question is raised about the original's authenticity, which in this case there is, as the witness's credibility is in question.
All right, the court's going to overrule the objection. Credibility will go to the jury, and you can hit the issue on cross-examination if you like. Next question, please.
Can you please start by reading the third text message sent by Avery?
Avery sent, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
And what did you respond to that?
I responded, "What are you going to do to his house?"
And what did Avery text you next?
"I'm going to wait until he's at work, then break in and trash it. That'll show him."
Thank you, co-counsel. You can stop sharing. Was this the last text message you received?
Yes, it was.
And after that, what happened?
After that, I learned that Mr. Brackman was murdered.
Moving on, did you have an interview with an investigator?
Yes, I did, and she accused me of faking those text messages.
Did you fabricate those text messages?
No, never. Avery was one of my best friends.
Moving on, I would like to talk about a student named Blair Rollins. Does Blair Rollins attend Colorado High School?
He did, yes.
Did you know Blair Rollins?
Not really. We did go to the same school, so I might have said hello to him in the hallway a couple of times, but I barely knew him.
Lastly, I would like to ask if you and Avery Becker were rivals.
Of course not. Of course not. Avery and I were teammates and friends.
Thank you. No further questions.
All right, cross-examination.
Apologies. May I be briefly excused as I figure out how to get the lights on again?
Counsel, do you want to have him adjust the lights, or are you ready for cross-examination?
He can adjust the lights, Your Honor.
All right, we'll just take a brief timeout then.
All right.
All right, cross-examination.
Thank you, Your Honor. Hello, Mr. Cifuentes. You work very hard in mock trial. Is that right?
Yes, I do.
Isn't it true that you spend a considerable amount of time writing for mock trial?
Yes, I do.
And you not only spend time writing, but you also have to practice for mock trial. Is that right?
Yep, we do.
And on top of all of that, you have to memorize loads of information for mock trial. Is that correct?
Yes, that is.
And from what you've observed, Avery Becker does not work nearly as hard as you do. Is that right?
No, Avery really didn't put too much practice into mock trial.
Miss Becker seemed to just waltz into competitions unprepared. Isn't that right?
She always came in unprepared, but she was very good at making things up on the spot.
And yet, Miss Becker, not you, won the Best Attorney Award at the regional tournament. Isn't that true?
Yes, she did.
And so it irked you, did it not, that you had put in so much hard work. Meanwhile, Miss Becker won all the awards.
I mean, why wouldn't it?
And you believe that Miss Becker was just getting by on good looks alone and likely won the awards on that basis.
Relevance.
I'm sorry, I couldn't hear you.
Objection relevance.
Okay, relevance.
Your
Response?
Honor, this goes to the credibility of the witness and his relationship to the defendant.
Reply.
Your Honor, I don't see what is relevant based if Alex thought Avery got based back on good looks or not. Therefore, I stand with my objection that this isn't relevant to the trial today.
All right, thank you. The court's going to overrule the objection. Next question.
To repeat my question, Mr. Cifuentes, you believe that Miss Becker was just getting by on good looks alone and likely won the awards on that basis, correct?
Well, good looks was part of it, but another part of it was just some unfair judging of the mock trial competition.
And you believe that she was winning not because of any real talent, right?
No, she wasn't winning because of her talent.
Now I'd like to turn your attention to the day before Mr. Brackman's murder. You were at the Fry Shack that night, correct?
Yes, I was.
And Miss Becker and Miss Perkins, they were there as well, right?
Yes, they were.
And at the Fry Shack, you had Miss Becker's phone, didn't you?
Yeah, Avery let me play some games on it.
So you had Miss Becker's phone. You were holding it in your hands, correct?
Yes, I was.
Now I'd like to talk about the day you went in to be interviewed about Mr. Brackman's murder. Mr. Cifuentes, you claim that you received text messages from Avery Becker on the day Mr. Brackman's car was vandalized. Is that right?
Yes, I did. That would be Exhibit 14.
And what Miss Becker is saying in these alleged text messages is crucial to making the claim that she is the killer of Mr. Brackman. Would you say so?
I'm not really sure on that.
Well, of course, I understand you're a high school student and not a police detective, but as the hard-working mock trial student we've established you are, you seem to pride yourself in your wealth of knowledge about crimes and evidence. Isn't that right?
Objection speculation.
Response.
Your Honor, we've already established that the witness is a hardworking mock trial student. I'm simply questioning him as to his belief, as to his knowledge on the evidence and crimes.
Your Honor, may I respond?
You may.
This witness is a high school student, has no degree in criminal justice, therefore, and they cannot testify on facts as they don't have any education to back that up. Mock trial is a club.
Anything further from the defense?
I understand that Mr. Cifuentes is not a police detective, but I'm simply establishing that he does have ample knowledge on crimes and evidence, and that does apply to this particular scenario.
All right, the court's going to sustain the objection. Next question.
Mr. Cifuentes, these text messages, they were located on your phone, correct?
Yes, they were.
And yet, you did not bring your phone to the police station. Isn't that right?
No, I forgot it because it had to be left on a charger. The battery was going on it.
So after you left your house to go to the police station, do you recall when you first realized you left your phone at home?
No, I don't.
But even once you were already at the police station, you did not drive back home and retrieve your phone. Isn't that right?
Well, it may have been too much of a hassle to do that. Plus, the detective told me it was fine to just send screenshots.
So can we see your phone now then?
No, I got rid of it about 3 months ago. Again, the battery on it was going, so I needed to get a new one.
So, Mr. Cifuentes, are you saying that to this day, the only person that has seen these supposed text messages on your actual phone is you?
On my phone, yes, but we have all seen the screenshots.
No further questions, Your Honor.
All right, redirect.
Yes, Your Honor. Why did you leave your home? Why did you leave your phone at home?
Because the battery was going, I needed to leave it on a charger at all times, and I was being interviewed at a police station. I was more than a little stressed, so I just forgot about it on accident.
And lastly, even though the detective never saw your phone, would you ever do anything to frame Avery?
Of course not. We were basically best friends.
Thank you. No further questions.
All right, thank you very much. Next witness, please.
The prosecution calls Kyle Cusack to the stand. One thing, Your Honor, before we begin, could I get a time check from our timekeeper?
You may. How much time is left from the timekeeper? Looks like it says 13 minutes just popped up in the chat.
Okay. Good morning, Kyle. Good morning, Kyle Cusack. Can you state your name and spell it for the court record, please?
My name is Kyle Cusack, K-U-Z-A-K. My student name is Damilola Adekola.
Okay. To begin, what is your occupation?
I am a crime scene reconstruction investigator.
Do you have any certifications for that?
Yes, I'm certified by the Colorado Bureau of Investigation.
What do you investigate as a crime scene reconstruction officer?
I investigate complex crime scenes such as home invasions, burglaries, other property crimes, homicides, domestic violence, fatal accidents, and armed robberies.
And how many years of experience do you have doing this?
I have 19 years of experience.
Where have you spent those recent years?
For 3 years with the city of Denver as a civilian employee of the Denver Police Department.
Okay. Your Honor, I move for Kyle Cusack to be admitted as an expert on crime scene reconstruction on the basis of their extensive, specialized knowledge of crime scene reconstruction, variety of experience dealing with these specific sorts of crimes, and relevant experience to this case.
Any objection?
No objections, Your Honor.
All right, she's so qualified.
Thank you. Should we pause? The timekeepers are... Okay, there was clarification in the chat. Moving on to your crime scene process, in general, do you have a certain way that you approach cases?
Yes.
And what is it?
I approach cases with 2 key principles. First, I assume that every case is going to trial, so I conduct a thorough and comprehensive investigation. Second, from the start, I memorize, document, and organize all evidence with the intent of future reconstruction.
Okay, and what process do you usually use with these principles?
I break these principles down into 5 parts, which are recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and lastly, reconstruction.
Moving on to this case, are you familiar with 444 South Flower Street?
Yes, that is where Mackenzie Brackman was murdered.
And would you consider this a crime scene?
Yes.
And what address and what county is this address in?
Denver.
Did you visit said crime scene?
Yes.
Okay. Did you implement the process you mentioned previously for this specific investigation?
Yes, I did.
To begin, what were the first steps that you took in your process when implementing it into this case?
I used a witness tracking spreadsheet to summarize key points of information from witnesses and suspects. I also used a physical evidence tracking sheet to link ID numbers from the scene to department evidence numbers and reference reports. Additionally, I made a rough flow chart to show the general idea of the events that took place.
And what were the steps you took after that?
I expand the initial rough draft, allowing room for information, evidence, and images to connect back to evidentiary relationships, lab submissions, and analysis. I make connections between the evidence with spreadsheets Using these spreadsheets, I note relationships, use photographs, and cross-reference items to come to a chronological conclusion.
And after collecting evidence, what did you do?
I did an analysis and final reconstruction on what happened on March 6, 2020.
So let's talk about what happened on March 6, 2020. Based on your reconstruction, what was the first event?
The perpetrator approached the front door and was seen by an additional security guard going to the back gate, entering through the back gate, and 10 seconds later appeared at the back door with another security camera and was seen going inside the home through the back sliding door.
And how did the perpetrator look physically?
They matched the general height and build of the defendant, Avery Becker.
During this time, what do you believe the victim was doing?
I think that the victim was notified by the ring notification and armed themselves with a knife.
And when the perpetrator entered the household, what happened?
There was a scuffle that moved to the front door that ended up with the perpetrator putting the victim into a bear hug and stabbing him in the back. The victim then pulled the knife out of their back and collapsed onto the floor.
How did you come to the conclusion that the scuffle had moved to the front door?
The photos of the blood cast off on the wall near the front door, as well as the small drops of blood between the kitchen and the front door.
How did you arrive at the conclusion that there was a scuffle in the first place?
There were scuff marks on the floor in the kitchen, the open knife drawer, the missing knife from the knife block, and the broken plate.
I wish to show Exhibit 6 to the witness. May the witness view Exhibit 6, Your Honor?
You may publish it to the witness, yes.
Permission for co-counsel to screen share?
Granted.
Thank you. Okay. I now show you what has been marked for identification as Exhibit 6. Would you identify it, please?
Yes, this is a photo I took at the lab of the knife that was found next to the victim's body.
What are the dimensions of this knife?
The knife is 12 inches from the tip of the blade to the base of the handle. It is 7.5 inches from the tip of the blade to the bottom of the blade, and it is 2.5 inches at the widest point of the blade.
Did these dimensions match the stab wound found on the victim?
Yes, it matched the incision and the path exactly.
And has this exhibit been altered in any way since you took this photo?
No.
Okay, Your Honor, at this time, I move for the admission of Exhibit 6 into evidence.
Any objection to the admission of Exhibit 6?
Your Honor, no objections.
All right, it's admitted.
And Your Honor, permission to publish Exhibit 6 to the jury?
You may.
Thank you. At the crime scene, what kind of knife was missing from the knife block?
It was a large chef knife.
Was this consistent with the knife found next to the body in this picture?
Yes.
Thank you. Co-counsel may stop screen sharing now. Thank you. Moving on to reports. Have you read any other expert reports in this case?
Yes, including Blake Van Owens.
Did you agree with Blake Van Owens' conclusion?
No, I did not.
Why?
He says that the victim was surprised, but the ring notification and the sliding door opening doesn't match up with that.
In your expert opinion, is Blake Van Owens' report consistent with the evidence presented at the scene?
No.
No further questions, Your Honor.
All right, cross-examination.
All right. Hello, Ms. Cusack. You are a crime scene reconstructionist, right?
Yes.
You pride yourself on your thoroughness as an investigator, correct?
Yes.
And you believe the defendant's guilt is based entirely on the select evidence you received, correct?
Yes.
Moving to the evidence, may I refer you to Exhibit 9? Your Honor, permission to screen share as a lay foundation.
Granted.
Ms. Cusack, do you know what this image is?
Yes.
What is this image?
It is an image of broken plate pieces on the ground next to a table.
And do you know where this image is taken from?
Yes, in Mackenzie Brackman's kitchen.
And do you know around the date this image was taken from?
Yes, the date of the murder, March 6, 2020.
And this is an accurate representation of what you use to base your conclusions off of.
Yes.
Your Honor, I now move to admit Exhibits 9 into evidence.
Any objection to Exhibit 9?
No objections, Your Honor.
9 is admitted.
Now, Ms. Cusack, you believe from Exhibit 9 the broken plate indicates a struggle, correct?
Yes.
Are you aware plates can break for a multitude of reasons? Are you not?
Yes, I'm aware that they can break for a multitude of reasons, but I mean, from the things that happened inside that home, it's plausible that a broken plate would come from some type of struggle that happened in the house.
Isn't it true that normally during a struggle, as you've seen in your experience, multiple items get displaced in the home?
Yes.
And so, yet in Exhibit 9, are there any other indications besides the singular broken plate on the ground that indicate a struggle?
No, but the broken plate is a pretty big one.
All right. Now, moving on to Exhibits 18. Your Honor, permission to publish Exhibit 18 to the witness as a lay foundation.
Granted.
Ms. Cusack, do you know what this image is?
Yes, it's the scuff marks on the floor in the kitchen.
And do you know when these were taken?
Yes, on the day of the murder.
And do you know where these were taken?
I'm sorry, can you repeat that?
And do you know where these were taken?
Yes, in the kitchen of Mackenzie Brackman.
And are these an accurate representation of what you use to make conclusions?
Yes.
Your Honor, I now move to admit Exhibit 18 as admissible evidence.
Any objection?
No objection, Your Honor.
18 is admitted.
Now, are you aware that scuff marks can be made at any point in time?
Yes, I'm aware that they can be made at any time, but as I said before, because of the events that took place in this house, it's very possible that those scuff marks were caused from the scuffle that happened in the house.
And do you have any way to date those scuff marks?
No, but like I've said again, it's quite plausible that these scuff marks can be caused from what happened.
I'm aware that anything could be possible, and I'm asking you, so these scuff marks can be made at any point in time, correct?
Yes.
And so isn't it true that scuff marks could have absolutely nothing to do with Brackman's murder, but simply a result of the home?
It could.
Right, now, moving to the blood supposedly on scene. You saw blood on the scene, correct?
Yes.
Blood that would supposedly be indicative of Brackman removing the knife himself, correct?
Yes.
Yet you do not have these photos to show the court, do you?
No, I do not.
So the only people who saw these supposed images was you and the detective on the scene, correct?
Yes.
And you have no proof now that they ever existed besides your own memory, correct?
Correct.
No further questions.
All right. Anything further from the prosecution?
Permission to redirect.
Granted.
Thank you, Your Honor. Your conclusion wasn't solely based on one piece of evidence, correct?
Yes.
It was a combination of multiple things and evidence found at the scene?
Yes.
And did you use most of the evidence found at the scene to reconstruct your events at the crime scene?
Yes.
And did the loss of the pictures of the blood spatter impede on your analysis of said crime scene?
No.
Objection leading.
Any response?
This isn't a leading question. I'm simply asking, it's a yes or no. The witness has the opportunity to say yes or no. Permission to restate.
Will be, why don't you restate your question?
Permission to restate, thank you.
Is sustained.
Did the loss of the pictures, Did the loss of the pictures influence you in any way?
No, they didn't.
Okay, that's all for redirect. Thank you.
Thank you very much. Further evidence from the prosecution?
Yes, Your Honor. The prosecution would like to call Detective Jordan Markowitz.
All right. All right, you may proceed.
Can I get a time check before I proceed?
You may.
Thank you. It's appreciated. Now, could you please state your name and spell the last for the record?
Yes, my name is Jordan Markowitz, Markowitz.
I would first like to talk about your involvement in this case. Can you please describe what that is?
Yeah, so I was involved as a detective investigating the death of Mackenzie Brockman.
And I would like you to delve into your occupation a bit more. Can you please describe it?
So I currently work for the Denver Police Department as a homicide detective, and I have particular experience in the field of cellular technology.
How long have you worked for the Denver Police Department?
A grand total of 13 years, with 7 of them being a detective.
And do you have any training with your specialty?
Yeah, so in terms of cellular technology, I've gained a certification in cell phone technology and forensics data recovery from the American Academy of Law Enforcement.
How often do you use this particular specialty?
Oh, I use it on a regular basis. I've used it to download information from hundreds of phones, and I've used it in over 50 cases.
Your Honor, it is at this time I move to enter Detective Jordan Markowitz as an expert not only in detective work, but also with a field in cellular technology.
Any objection to her qualifications?
Your Honor, no objections.
All right, she's qualified to give opinions in that area.
Now, I would like to move on to the date of March 6, 2020, the day of the murder. What is your involvement in that day?
So initially, a passing motorist saw the scene and they immediately called 911. And then paramedics initially responded, and then uniformed officers secured the scene, and then I responded to the crime scene.
If co-counsel could, permission for co-counsel to screen share Exhibit 1. Your Honor.
Granted. Can you hear me okay? Yes,
Yeah.
Apologies, technical difficulties. It's coming up right now.
All right. Do you mind if I continue without the? Okay, we're good. Can you please describe what this is?
So this is an image of Mackenzie Brockman lying face down in his residence.
Is this an accurate depiction on what you saw the date of March 6, 2020?
Yes.
Has this been edited in any way, shape, or form since you last saw it?
No.
I would now like to enter Exhibit 1 into evidence.
Any objection to the admission of Exhibit 1?
Your Honor, no objections.
All right, Exhibit 1 is admitted.
I would now like to talk about what you witnessed at Brockman's residence. Can you please describe it?
So upon entering the scene, I immediately noticed that the front door of Brockman's residence was open, and just inside of it, as we can see in this image, was Mackenzie Brockman, the victim, lying face down unconscious in a pool of his own blood. And while also standing outside of the house, I also noticed that Brockman had a Ring doorbell system around his residence.
Did you do some investigation on the inside as well?
Yeah, so when I walked inside, I first noticed that the house was slightly in disarray. There was a kitchen drawer that was partially open that had a bunch of knives in it. There was also a knife block on the counter that had a knife missing from the knife block. And then there were blood drops all around the scene.
Were there any other notable observations?
Yeah, I also noticed that next to Brockman's body, there was a knife on the floor. And around that knife and around the rest of the scene, there was blood, and there was also some cast off blood splatter on the wall and the ceilings.
Thank you. Co-counsel can stop screen sharing now. You mentioned another form of technology earlier. Can you please describe what that was?
So I used the Ring camera system, which I observed, as I mentioned earlier, was located on the outside of Brockman's residence.
And did you gain access to that information?
Yeah, so I gained access after downloading information from Brockman's phone, and there I was able to get access to his Ring account data as well as all of those passwords.
Well, then what did you find?
So when I logged into the Ring account, I first noticed that Brockman had, lucky for us, paid a little extra fee to get extended coverage of the events on March 6, 2020 on his Ring camera system.
It is at this time I request co-counsel screen share for permission for co-counsel to screen share any of the documents listed from evidence 10 through 13.
Okay, which one would you like up first?
Anyone. It doesn't really matter for this line of questioning.
Well, why don't you tell them which one you want up so that they know what to do?
We'll just go with 10 to make things easier.
Thank you.
Can you please describe what this video is showing?
Yeah, so this video is showing the intruder on the outside of Brockman's house and then attempting to get in.
Where was this taken?
This was taken from the Ring camera system on Brockman's residence.
Has this been changed in any way, shape, or form since you last saw it?
No.
And what date is this from?
March 6, 2020.
Your Honor, I would now like to enter exhibits 10 through 13 into evidence, the Ring account videos.
Any objection to 10 through 13?
Your Honor, no objections.
All right, 10 through 13 are admitted.
Thank you. Co-counsel may stop screen sharing now. I would now like to move on to the topic of your usage of cellular technology. For your involvement in this case, did you contact anyone?
Yeah, so after downloading all the information from Brockman's phone, I discovered he was a part of this extracurricular activity at Colorado High School called Mock Trial. And from there, from Colorado High School, I received contacts from all the students on the Mock Trial team. And then I went through and attempted to contact all of those interviewers. And the most notable interview I got was from Alex Cifuentes.
And what was one of the things you did utilizing cellular technology?
So after my interview with Alex Cifuentes, I learned about some existing tension between the defendant Avery Becker as well as the victim Mackenzie Brockman. And so from there, I just set out to find out any information that I could about Avery Becker and their cellular records.
And with minimal information given to do so, were you still able to gain those records?
Yeah, so I had to obtain a search warrant to get Becker's cell phone. However, Becker's attorney said it was mysteriously lost on March 5th. And then since the attorney merely provided with that phone number, I had to obtain a court order to get access to Becker's service provider.
And what information did you gain?
I got cell tower records as well as call detail records, which are also known as CDRs.
What are call detail records?
So CDRs represent any interaction between a cell phone as well as a cell tower, and that can be through a text or a call.
Now, I would like for permission for co-counsel to screen share Exhibit 15.
Granted.
Can you describe what this is?
Sure. So this is the diagram of the CDRs for Becker's phone. It shows which cell towers Becker's phone was connected to at a certain time, as well as the tower's ranges.
And what date is this from?
March 6, 2020, the day of the murder.
And has this document been changed in any way, shape, or form since you last saw it?
No.
Your Honor, I move to enter Exhibit 15 into evidence.
Any objection to the admission of 15?
Your Honor, no objections.
All right, 15 is admitted.
Now, can you please describe what this document portrays?
Yeah, so again, this shows all the interactions between Becker's and the cell phone and the cell towers. So initially, you can see at 12:47, it shows that Becker's phone is connected to a tower that is closest to Becker's residence. And then at 12:47 or 12:55, the Becker's phone is connected to a tower near Rock Creek Parkway, which I presume is a road that could be used to get from Becker's to Brockman's house. And that at 105, 106, and 117, there were connections from Becker's phone to the cell tower closest to Brockman's residence. And then after that, all activity ceased.
And how is this information useful?
So basically all that information just indicates where Becker's phone was located throughout the day on March 6th.
With all of this information gathered, what is your expert theory on what occurred on March 6, 2020?
So based on all the evidence I was able to collect, in my expert opinion, Becker drove from Becker's house to Brockman's residence, broke into Brockman's residence, made use of a knife, and stabbed Mackenzie Brockman, all resulting in the very, very untimely death of Mackenzie Brockman.
Thank you. No further questions.
All right, cross-examination.
Detective Markowitz, would you consider yourself an expert at your job?
I would consider myself an expert in cellular technology, yes.
And you believe it's extremely important to follow up on all leads, correct?
That's true.
And so why did you not investigate an ex-client?
Well, it was a very unlikely possibility, and I had all the information I needed on potential witnesses and potential suspects, and I did not have sufficient evidence to interview or get any further information on Blair Rollins.
But that's because you never even looked into it, did you?
Right, I had all the information I needed from Alex Cifuentes about potential suspects, so I was satisfied with the evidence I obtained.
Now moving on to the crime scene, you found blood at the scene, right?
Correct, there were blood drops as well as cast-off blood splatter.
And the blood that you found was on the shirt, correct?
Correct, there was some blood on Mackenzie Brockman's shirt.
And there was some cast off on the wall?
Yes.
But the blood that you found all came from the stab wound, correct? That's what you said?
Objection, relevance?
Your Honor, this has to go with credibility of the witness, and this is laying foundation for my next questions.
Any further argument from the prosecution?
We already know about the victim, Mackenzie Brockman's murder. However, this does not make a fact in the case on what occurred as well as who was involved, more or less likely.
Your Honor, may I respond?
You may.
This does have to do what actually occurred, and I will prove that in my next questions.
All right, we'll give you some leeway.
But the blood that you found all came from the stab wound, correct?
Well, I'm not an expert in stab wounds, so I can't give you my full conclusion on that. However, I would presume based off of my experience that yes, most of that blood came from that stab wound.
But that is what you said in your witness statement, right?
Correct.
So what you're saying is the only blood found on the scene is Brackman pulling the knife, correct?
Yes,
Objection,
once again.
speculation.
I'm sorry, I didn't catch the objection.
Speculation. This is asking my witness to speculate what occurred.
All right, response to the speculation objection.
Yes, they were at the crime scene. They were able to observe what happened, and they're giving their expert opinion.
Go ahead.
I may respond.
Please.
This goes beyond the scope of what their expertise was in, as well as them not being someone who is an expert in specifically figuring out what occurred.
Response
Your
to
Honor,
that?
they made it known that that's what they thought happened. This is all what they believed.
Why don't you rephrase your question?
The only blood you found on the scene is Brackman pulling a knife. There's no blood in the kitchen or in the hallway?
No, the blood splatter that I noticed was around the death as well as on the wall and ceilings.
So what you're saying is that the intruder had to grab the knife from Brackman, a sharp knife, a long knife, and neither the intruder nor Mr. Brackman got cut in that struggle. Is that correct?
Once again, I'm an expert in cellular technology, so I can't make vast conclusions based off of that. But based off of my experience, in my opinion, yes, that's what I believe occurred.
You believe that no signs of a struggle between the knife and blood happened?
Once again, that's not my field of expertise. However, based off my experience, yes, that's what I believe.
Now, moving on, you talked with a Mr. Cifuentes, is that correct?
Correct.
And you accepted screenshots instead of seeing the actual phone, correct?
Right, I trusted Alex Cifuentes to gain information from his own phone as he didn't bring it to the interview, and I gained screenshots as my source of evidence, yes.
And you are aware that screenshots can be faked?
Yes, that's true. It is a possibility that screenshots can be faked. However, based off of my knowledge, I trusted Cifuentes to gain screenshots.
So you assumed and trusted that these screenshots were correct?
Once again, it was only a source of evidence that I used to get to the suspect. There were many other factors, including the CDRs and the ring system that went into that. So it wasn't the prime source of evidence. Therefore, I didn't feel the need to go out and gain the evidence myself.
So the only person that ever actually saw the text messages on Mr. Cifuentes' phone is himself, correct?
Yes, however, that wasn't my prime source of evidence, so I didn't feel the need to gain it myself.
Okay, and now you said that a cell phone usually connects with the best available tower, correct?
Usually it connects to the best available tower, yes.
And that's not necessarily the closest tower, is it?
If the cell tower is particularly busy and the cell phone isn't able to gain a connection to that tower and needs to gain a connection to a less busy tower, yes, that's a possibility.
All right, and finally, while you were at the crime scene, you noticed scuff marks, correct?
Correct. I did notice some scuff marks, but once again, that's not my expertise, so I cannot make any conclusions based off of that.
All right. So finally, you only accepted screenshots from Mr. Cifuentes, correct?
Objection asked and answered.
Response to the asked and answered objection?
Yes, I'm just rephrasing. I can move on if needed.
All right, why don't you do that?
And finally, you believe that a cell phone can connect with the best available tower, not necessarily the closest, correct?
That's true. It usually does connect to the closest tower, as that only occurs if the cell tower is particularly busy and the phone needs to connect to a less busy one, but usually it connects to the closest tower.
Thank you, Your Honor. No further questions.
All right, anything further for this witness from the prosecution?
Permission to perform a brief redirect as soon as I get a time check.
Granted.
Apparently not. No redirect, seeing as we only have 1 second.
I think Miss Grosshands meant that she was waiting to get it up. And she
was hanging on. Okay, you have 4 minutes left. All right, you may proceed.
Sorry.
Oh, geez, I'm doing math.
Can you please describe the build? If you could please turn your attention to Exhibit 10 and describe the build of the person in the video.
Based off of my
objection, beyond the scope, I didn't address this in my cross.
Okay, the response to the scope objection.
Seeing as this is a redirect to gain a further understanding of the situation, this is also laying foundation as to what is going to be discussed later.
Later in your redirect?
Yes. If you would like me to explain my thinking process, I could also do that.
I'll give you a little bit of leeway.
Thank you.
You may answer the question.
Well, based off my observation, I noticed that the person was wearing all black, they had gloves on, and they had a Halloween mask on.
And did they match anyone in particular that you knew of?
Yes, I would presume based off of, while I'm not an expert in that, based off my conclusions, they did appear to match the build of Avery Becker.
And in cross-examination, opposing counsel discussed the likelihood of cell towers. Can you please restate? Apologies, let me rephrase. Is is there a large possibility that the authenticity of the exhibit 15 is admissible?
No, there's not a large source for error. It is an authentic and credible evidence.
Your Honor, objection beyond the scope. I did not address this.
All right, beyond the scope, response to that?
This is within the witness's scope to answer due to their expertise in cellular technology, as well as the cross-examination containing an attempts to discredit exhibit 15 in terms of reliability, in which I'm addressing here on direct.
Do you think it was in responsive to something that the defense inquired about on cross-examination?
Yes.
What?
Your Honor, may I respond?
Earlier opposing counsel was discussing the likelihood of connecting to more distant cell towers, and I'm attempting to address the plausibility of the connection of the towers as well.
Right. Counsel, you may.
I never specifically brought up exhibit 15.
I agree. Sustained. Any further redirect?
No, Your Honor.
Very good. Any further witnesses from the prosecution?
No, Your Honor, the prosecution rests.
All right. Is the defense ready to proceed?
Yes, Your Honor. The defense calls Blake Van Owen to the stand.
Okay, you may inquire.
Good morning, Professor. Could you please introduce yourself to the jury?
Hi, my name is Blake Van Owen.
And what do you do for a living?
I work as a private investigator, expert witness in mainly police practices, and professor. I have served as an expert witness in over 100 cases on a range of topics, from crime scene reconstruction, cell tower analysis, and general police investigation tactics. And I also used to be a police officer with the APD for 9 months between 2005 and 2006. And I have a master's degree in criminal justice, a BA in English, and I am now a professor who teaches a course at CU Denver on police practice and social justice.
Your Honor, I now offer Professor Blake Van Owen as an expert in the field of homicide investigation and cell tower analysis.
Any objection?
Your Honor, permission to do a quick voir dire.
Granted.
Thank you. Good afternoon, Ms. Van Owen. You didn't talk about where you got your undergraduate degree from, did you?
Sorry, no, I do not believe so.
And you don't mention how long you've been a private investigator for?
I don't think that was what my attorney said, but
you don't, in your statement, you don't discuss how long you've been a private investigator.
No, but I have done it since I ended my work with the APD.
And then you were a police officer with the Denver Police Department for less than a year. Is that what I heard?
9 months.
And you don't have any formal training in cell tower analysis, correct?
I have lots of training, actually. I've been doing it for a long time.
But you have no formal training, correct?
What would that mean?
Studying, having a training course, learning, gaining education.
I have gained a lot of education from my past experiences and redoing many trials on this topic.
Did you take any specific courses related to cell tower analysis?
No.
Okay. And have you taken any specific courses related to crime scene reconstruction?
I've done it many times. I've got a lot of experience in this unit.
Specific courses?
No.
Okay. And you don't mention the roles that you played when consulting on the cases that you mentioned.
What do you mean by that?
Do you discuss the roles that you play in the cases you discussed in the previous question?
Like I'm on the defense side? What is this type of?
Let me rephrase
Your
the question.
Honor, relevance under Rule 702, you can be an expert based off of experience and not just educational training.
Right, the
Um,
objection really goes to why is the qualifications versus credibility?
May I respond, Your Honor?
Please.
This is discussing their experience. This question is directly talking about the roles and experience that they've had in previous cases, which would be considered experience.
All right, the 702 objection is overruled. You may further voir dire if you like.
Okay, thank you. So you don't mention the roles you play, the parts you took in the cases you were a part of.
In my past cases?
Yes.
I don't believe so, but I don't understand why that would matter.
Okay, thank you. Your Honor, I request that this witness not be qualified as an expert in cell phone tracking or crime scene reconstruction based on their lack of experience in cases that they've mentioned and their lack of training and formal training in relation to this case under cell phone tower analysis and crime scene reconstruction. Their past experience is vague and they have no formal.
Okay, response?
Your Honor, not only does this witness have ample qualifications in her educational background, but she also has testified in over 100 cases as an expert witness, including topics such as cell tower analysis and homicide investigation, which under Rule 702 qualifies Professor Van Owen as an expert.
Anything further from the, I'm sorry, for the prosecution?
I stand with my statement.
Okay, the court's going to overrule the objection. Court finds that the issues go to the weight of her testimony rather than her qualifications.
Thank you, Your Honor. Professor, you were only a police officer with the APD for 9 months, as you already stated. Could you explain why?
As my time as a police officer with the APD, I ended up injuring a young woman of color using all top police practices, and she ended up suing me and the APD individually, but I was cleared for wrongdoing since I was using all of the police taught practices and nothing else.
How has this incident impacted you?
I have
Objection relevance.
Relevance?
Your Honor, this goes to the witness's credibility and establishes how she has grown as a detective and how her scope on the case is objective.
May I respond to that, Your Honor?
You may.
This question of asking how she felt and how that previous question doesn't directly go into anything we're discussing in this trial today, especially since the incident that the opposing counsel is referring to is a case that didn't have anything to do with the trial. So this isn't relevant to today's case.
All right, anything further from the defense?
No, Your Honor, may I move on?
The court's going to overrule the objection.
Thank you. Professor, how has this incident impacted you?
I have grown from this incident, and now I use this as a silver lining to put me in my position where now I teach a course on police practices and social justice. I use this experience to see the fault within police practices and broader community of the police departments.
And Professor, you have always testified on the side of the defense. Why is that?
Because the prosecution already has the cops on their side for free. So why would they need to pay an individual expert, such as me, to provide the same effort that the police provides for free?
Thank you for clarifying that. Now on to the case. Professor, did you review the prosecution's case as well as all relevant evidence and witness statements?
Back and forth, yes, I did.
And what is your theory of what happened in the moments leading up to Mr. Brackman's murder?
I believe Mr. Brackman was sitting down in his kitchen when an intruder, who was of the same general build as Brackman was, intruded through his back door and purposefully stabbed Brackman in the back, surprising him.
Do you think the murder was premeditated?
Yes, it would make far more sense with a strong person with a strong motive to premeditate and plan the murder of Mackenzie Brackman.
And what is the physical evidence that helps you come to the conclusion that the murder was in fact premeditated?
Lots of things. The autopsy report, the reconstruction of the knife position, ring videos, cell tower reports, past clients of Mackenzie Brackman, knife dimensions.
And what is your explanation for the scuff marks found on the floor in Brackman's kitchen?
Scuff marks could have been made at any time. There's no way to carbon date that these scuff marks were made at the time of the supposed struggle. So,
what do you think about the prosecution's theory about ring notifications?
I'm aware that the prosecution claims ring notifications would have notified Brackman as of an intruder coming through his back door, but as a user of Ring Doorbell, I understand that you can turn off push notifications, and I know that there's an option to turn off and on what you see from this, so I don't understand why the prosecution didn't follow through to see if the notifications were even on to know if Mr. Brackman was notified of this intruder.
And what is your understanding of how the knife would have been held to create Brackman's stab wound?
The knife position would have been facing downward in order to create this exact wound to the aorta. This method is less common than the reverse position, but it's not that uncommon.
Do you have any photographs demonstrating this position?
Yes, I do. I demonstrate it in Exhibit 21.
Your Honor, at this time, I move for the admission of Exhibit 21.
Any objection to the admission of 21?
No objections, Your Honor.
All right, 21 is admitted.
Permission to publish to the jury.
Granted.
Thank you, Your Honor. Professor, could you please give us a brief explanation of this photo, including the angle of the knife?
As I've demonstrated in this photo, this is how I chose to demonstrate how the knife would have been held in the cause of the replica. The knife would have been held to be facing downwards in this angle using significant force to create the exact wound in Brackman's body.
And what is your opinion as to the quality of investigation as conducted by Detective Markowitz and Kyle Kuzak in this case?
I think that the police did such a poor job investigating this crime. They rushed and missed many things during the case, and they have lots of threads, like they didn't follow through on all leads, such as Brackman's past clients, failure to follow up on like the actual phone. They should have asked to see the phone in real life instead of accepting merely screenshots. The assumption of the knife, since the knife was missing from the knife block, they didn't go to extent of measuring the knife dimensions as I
Lack
did.
of foundation.
Your response to the foundation objection?
Your Honor, this witness has been qualified as an expert, and therefore she is allowed to speak of her professional opinions based on the evidence and reports that she has reviewed.
May I respond, Your Honor?
You may.
The witness discusses the cell phone, and there were no previous questions discussing the screenshots or the cell phone in general. So there was no foundation setting up for that.
Anything further from the defense?
Your Honor, I stand on my response.
Okay. Court finds that it's a close question, but will allow it. Go ahead.
Thank you, Your Honor. Professor, would you like to continue?
Yes. They only examined a small part of their full investigation, which I think should have been done a lot better by the police. And I think that since I had to go through and rewrite their mistakes, I think that the police just did a horrible investigation.
And what steps did you take to think through possible suspects for Mr. Brackman's murder?
I looked at the evidence unbiasedly, and I looked at all possible people. I looked at the autopsy, the crime scene, the cell tower reports, and at my wealth of knowledge from my past to find what I found at the end of this trial.
Were there any suspects in particular that stood out to you as having a strong motive?
Yes, Blair Rollins.
And what evidence helped you come to this conclusion?
I believe that there is a recording proving the strong motive of Jonathan Rollins and his son.
And did you listen to this recording?
I did.
And listening to a recording like this, is that information that experts in your field routinely rely upon?
Very often.
Did the recording provide insight regarding motive for killing Mr. Brackman?
For sure.
Professor, I would now like you to look at what has been marked for identification as exhibit number 22. Would you identify this, please?
It's an audio recording from Jonathan Rollins, which revealed a clear motive to me.
Your Honor, at this time, I move for the admission of exhibit 22.
Any objection to exhibit 22?
Objection, lack of foundation.
Can you expand on your foundation objection?
There's not really a foundation or laying of a foundation. I actually changed my objection to hearsay. Because this is a statement made outside of trial that could prove the truth, that could alter the truth of the matter and make something seem more or less possible. So this falls under hearsay.
A response to the hearsay objection.
Yes, Your Honor. This is not hearsay, as it comes under multiple exceptions to the hearsay rule, including Rule 803, then existing mental, emotional, or physical conditions, and Rule 802, excited utterance by Jonathan Rollins.
Any reply to that? Excited utterance or present sense impression?
This doesn't fall, Your Honor, this doesn't fall under either of those exceptions because this was simply a person saying something in a courtroom. And I stand with my objection.
Okay. Objection sustained. Next question.
I'm sorry, Your Honor. So you sustain the objection of not admitting exhibit 22?
It is not admitted.
Okay. Now, Professor, switching topics, what do you consider the prosecution to have adequately investigated all those with potential motives for killing Mr. Brackman?
Not at all. I think we all can agree that getting kicked off of a mock trial team is merely a reason to murder a human being.
And in conclusion, after analyzing all the facts and all the possibilities, do you believe Avery Becker murdered Mackenzie Brackman?
I know for certain that Avery Becker is innocent of this crime and Blair Rollins has far more of a motive.
Thank you, Professor. No further questions, Your Honor.
Cross-examination.
Thank you, Your Honor. To begin, I would like to first talk to you about your involvement in this case. You have already been paid $7,000 up to date in this investigation, correct?
Yes.
Objection, Your Honor, beyond the scope. I never referenced the witness's payment in my direct examination.
Response.
Yeah,
response to the scope objection.
This isn't beyond the scope. This is simply what the witness is discussing in their witness statement, and this is a very relevant piece of information. And it also proves bias. So this is not beyond the scope because in the direct, they refer to Blake Van Owen being a part of this trial, and their payment is a part of this trial.
Anything further from the defense?
Your Honor, I stand on my objection. We never specifically mentioned payment or the details of Professor Van Owen's payment in this case.
Well, that's true. It does go to credibility. Overruled.
Okay, would you like me to restate the question?
That's all right. No problem. Yes, I am paid for this job.
And you are being paid at least $8,000 in total to find evidence to support the defendant.
Yes.
And you have only ever testified on the side of the defense?
I have, and I proved as to why.
And for this current case, you stated that you only conducted a partial investigation. Is that correct?
I believe if you reread that line that I did a partial investigation on the police's half. I did a full investigation, but I didn't need to repeat Mr. Markowitz's work. So you didn't conduct a full investigation? I did. I went through all of the reports and I explained the mishaps between the police and the truth.
But you conducted a partial investigation on the side of the police, which you mentioned.
Why would I need to redo the work of Mr. Markowitz?
So did you just testify that you did a full investigation?
I did the investigation on Mr. Markowitz's behalf and my investigation.
And you made a statement prior to today.
What does that mean?
You made a witness statement, your witness statement?
Yes, I did.
You were able to update this statement at any point, correct?
Yes.
I wish to show the witness what has been previously marked. Give me one moment to pull it up. Never mind. Moving on. Okay, anyway, I apologize. So let's continue. You didn't conduct a full investigation. That is a yes.
I did a partial investigation on the police's behalf, is what I said in my witness statement.
So that's a yes.
On the police's behalf, so I had to do extra work because they mishapped their investigation.
Okay, thank you. And on the topic of your investigation, you conducted it without physically seeing the crime scene?
They didn't allow me to do so.
But you didn't see it. That's a yes.
Correct.
Okay. The victim being surprised by the perpetrator is just your theory, correct?
As I've concluded all of this from my evidence and the mishaps within the police's investigation.
Isn't it possible that the scuff marks were created during the scuffle?
Sure, but very unlikely. Why would they have what? That doesn't make any sense because the scuff marks could have been made at any time.
But is that a yes?
Sure.
Okay. And would you agree that twisting a door handle can make noise?
Yes, but it doesn't have any relevance to this because Mr. Brackman could have been working very hard or could have not even heard anything because he could have had any loss of hearing or anything.
Okay, and would you agree that opening doors can make noise?
Barely, but yes.
Okay, and opening a door could alert someone inside the house.
If one to be careful and have a motive to come into a house and murder someone, I don't think that they would purposefully make a noise. They would want to be very quiet.
I am simply asking if opening a door can alert a noise inside a house. Is that a yes?
Barely if they didn't want to.
Okay. And you don't discuss the possibility of Brackman hearing the door open or the handle being pulled in your investigation, did you?
I don't believe so, no.
Okay. I would now like to talk to you about some other students you discuss in your case, Blair Rollins and Alex Cifuentes. You never state how you learned that Alex Cifuentes and Blair Rollins were allegedly friends.
I didn't.
And you also never state the evidence indicating that Alex Cifuentes created fake text messages.
I'm sorry, can you repeat that?
You never state the evidence that Alex Cifuentes created fake text messages, correct?
Do I need to?
Simply a yes or no. Did you create the evidence? I mean, did you state the evidence you used?
There was no evidence.
So are you saying Alex Cifuentes did not doctor the screenshots?
I'm saying that he could have, but why would the police merely accept screenshots of a phone that they could have obtained otherwise?
You're saying Alex Cifuentes did not doctor the screenshots?
I'm not saying that.
Okay. And discussing the time period of events, this crime happened in March, correct?
March 6th, 2020.
And Blair Rollins left after graduation in May?
Pretty sure that he never came back to school after this incident. Never seen again.
Did you just state that he left and was never seen again after? Did you just testify that he left and was never seen again?
I'm pretty sure. That's what I just said.
Okay. Are you, and you made a statement prior to today?
I did.
You were able to update this statement at any point?
Mm-hmm. Yes.
I would now like to direct you to the statement called the Blake Van Owens affidavit. Permission to screen share.
Granted.
Thank you, Your Honor. Okay.
Yep.
Give me one moment. Okay. Could you read along in your head while I read out loud?
Could you point me to what line that is? My screen's a little foggy.
On line 264. Could you read in your head while I read aloud?
Yes, ma'am.
Blair Rollins essentially disappeared after graduation. Did you state this in your case?
I believe I just said that.
Yet you testified that he was never seen again.
That's what I just said. He disappeared after graduation. He wasn't seen again.
In your testimony, you stated that he left right after the crime, not after graduation.
Isn't that suspicious?
I'm simply asking if you testified that he left right after the crime.
The incident within like a window. I didn't mean exactly on that date he was never seen again, but he was within this time period he disappeared.
Okay, one moment. May I have a moment to discuss with co-counsel?
You may.
Thank you, Your Honor. Okay, moving on. Just a few more questions. So, moving on to Blair Rollins' connection with Avery Becker, you compared the height and build of Becker and Avery, correct? Becker and Rollins, correct?
Are you saying that they are of the same general build?
Actually, moving on, we're going to go to further steps. Avery Becker's phone communicated with a cell tower near Brackman's house the day of the murder, correct?
It did, but this is because it's
Thank
on
you. And Avery Becker was absent.
Objection, Your Honor. My witness has the right to finish answering the question.
Okay. Sorry. You can finish.
The cell tower can be connected with, since this is a popular route, and it's very likely that the phone connected with a more popular route than the most nearest one.
Okay. You say that being cut from mock trial is a motive, correct?
No.
In your statement, you say that being cut from mock trial is a motive.
Could you direct me to which line I say that?
I'm going to end the cross here. No further questions, Your Honor.
Thank you. Redirect.
Yes, Your Honor, briefly. Professor, did you examine all of the evidence and testimony in this case with an unbiased, objective approach?
Yes, I did.
And we are aware that you routinely testify on the side of the defense and you are paid to do so. But does this affect your approach of investigating the case in any way?
No, not at all. And I get paid hourly, and I am earning this much money because the police did such a poor job that I had to thoroughly go through and diligently use my time to go through all of their mistakes. So I've spent more hours than I should have on this.
Thank you. No further questions, Your Honor.
All right, great. Further evidence from the defense. Another witness, please.
Your Honor, we now call to the stand Taylor Perkins.
All right, you may proceed.
Hello, Ms. Perkins. Could you introduce yourself to the jury?
My name is Taylor Perkins, and I'm a freshman at CU Boulder.
Now, how do you know Ms. Becker?
Avery and I were really close friends in high school.
And was Ms. Becker on the mock trial team during the time of the murder last year?
No, she wasn't.
And why was that?
Her and Coach Brackman always got in some fights, and I think that one just went a little bit too far, and he kicked her off the team.
And in the same time frame, were you on the mock trial team?
I was not.
And why was that?
I'd stepped down because Avery had been demoted to B team. And since the team meant a lot to her, I thought it would be better if I moved down so that way she could regain her spot on A team.
All right, moving to the night before Brackman's death, March 5th, what happened that night?
That night, Avery and I went to the Fry Shack.
And what happened when you arrived at the Fry Shack?
When we were there, almost the entire mock trial team was there. It was pretty crazy, especially for Avery, because she had just gotten kicked off the team. So it definitely wasn't the best of situations.
Did you see anyone in particular from the mock trial team at the Fry Shack?
Yes, I saw Alex Cifuentes.
Now, Ms. Perkins, who is Alex Cifuentes?
Alex and Avery and I have all done mock trial together for almost 4 years. And Alex is just the kind of person that Avery and I don't really like to be around. He's not very nice. He always picks on Avery, and he's also extremely jealous of Avery too because of her success on mock trial.
Objection, speculation.
Response?
The witness is testifying as to her personal opinion on what Alex's views are based on her foundation of knowing Alex for almost 4 years on mock trial.
Your Honor, may I respond?
You may.
When this witness was testifying, she used Avery and I in her testimony today. She can testify on how she feels, but on behalf of Avery, she cannot testify on how Avery felt about Alex, as that would go to speculation.
Okay, sustained as to the last part that you were objecting to on how Avery was thinking, overruled if it went further than that. Next question.
All right. Now, why do you remember Mr. Fuentes specifically from this night?
Alex was being really annoying. He was all over Avery on her phone, just kind of, I guess, kicking her while she's down, especially because she had just gotten kicked off the mock trial team. So it really, I don't know, it just was really rude of Alex to do that.
Now, what did Avery do in response to that kind of behavior?
Avery went to the bathroom just to kind of cool down, take a breather, and yeah, she just kind of went away from the situation.
And then what happened after that?
After that, I thought it would be best if Avery and I just left the Fry Shack.
And where did you go from there?
We went to the mall to kind of calm down and just shop around together.
And then did you go anywhere else from the mall?
After that, we just went our separate ways and went back to our own houses.
All right, thank you. Now, moving to the day of the death of Mr. Brackman, March 6th, how did that morning start for you?
I woke up and Avery came to pick me up from school because we normally carpool together. And she told me that her phone was missing.
And when you guys both realized her phone was missing, what did you try to do?
We called and texted the phone first to see if it was anywhere nearby or if anyone would pick up the phone, but no one picked up the phone and we couldn't really hear it anywhere.
After your attempts to call the phone were unsuccessful, what further steps did you and Avery both take to find the phone?
Avery and I decided it would be best to retrace our steps. So first we went to the mall, looked through the lost and found, went to stores, just looked everywhere around the mall, and we couldn't find it anywhere in the mall.
And then after not finding it in the mall, then where else do you go to retrace your steps?
After that, we went back to the Fry Shack, which is where we were the night before, and we couldn't find it anywhere. We looked in the bathroom, we looked on the tables, and we couldn't find it anywhere.
And so when you were at the Fry Shack, did you see anything there besides the phone?
Yes, actually, the entire mock trial team was there, which was pretty weird because it was the time that they normally were supposed to be in mock trial practice.
Did you ask them why they weren't in mock trial practice when you were there?
Yes, they told us that Coach Brackman had never showed up.
And did this searching for the phone take a lot of the day?
Yes, it took the entire day from the morning all the way to about 6-ish, which is when mock trial practice started.
Now, Ms. Perkins, were you with Avery Becker all day?
Yes, I was with Avery the entire day.
All right, no further questions. Thank you.
All right, redirect.
Your Honor, before I start my cross, can I request a time check?
You may. There you go.
Thank you. Good morning, Ms. Perkins. You were on the mock trial team, correct?
Yes, I was.
And you were one of Avery's best friends.
Yes, we were really close in high school.
You thought that Mr. Brackman was a mediocre coach?
I definitely thought he was a mediocre coach, but he was pretty good, I guess you could say.
But that's still a yes.
Yes.
And you thought that he was an even more mediocre lawyer as well, correct?
I mean, I had never really seen him in court, but that was just my assumption, especially how it went down with some of his cases.
But that's still a yes.
Objection relevance?
Your Honor, may I respond?
You may respond.
I'm setting foundation, and it shows the witness's bias.
All right, give you a little leeway. You may proceed.
Moving on, moving on, Avery came unprepared to meetings.
Occasionally.
And she put little to no effort into mock trial.
Objection speculation.
May I respond?
You may.
As previously stated, this witness is Avery's best friend, as well as Taylor was on the mock trial team, therefore witnessed everything that was happening. Therefore, Taylor can testify if Avery put effort into mock trial or not.
You can testify as to her observations. Overruled.
I'm going to repeat my question. Avery put little to no effort into mock trial.
On occasion, she would show up unprepared, but mock trial meant a lot to her, so she definitely did her work to stay on the team.
But that's still a yes, correct?
Occasionally.
And you even stated that Avery could be rash and have an inflated ego at times.
Once again, this was only an occurrence maybe once or twice throughout my 4 years on mock trial with her, but it was pretty rare.
But that's still a yes.
It was very rare that would occur, so not really a yes or no.
But in your witness statement today, you stated that Avery could be rash and have an inflated ego, did you not?
Yes, I said she could, but it's not consistent, so I guess the answer to your question is partially yes.
And even you noticed a month before regionals, Avery came the most unprepared you had ever seen her.
Yes, she was a bit riled up, but yes.
And that made Brackman heated.
Yes, Coach Brackman did get a little bit upset when people would show up unprepared.
And he even got frustrated.
Correct.
And after those incidents, Brackman demoted her to the B team.
Yes, he did.
And then you decided to quit mock trial.
Mock trial meant a lot more to Avery than it did to me, especially because she was so successful on the team. So I thought it was my job as a friend to move down for her, or to.
But that's my apologies. That's still a yes, correct?
Yes, I did quit the team.
And when Avery was demoted to the B team, that made her upset that in permanent marker she wrote on Mr. Brackman's car, correct?
It was accidental. She thought it was a dry erase marker.
But she still wrote on Mr. Brackman's car?
Yes.
And after that incident, Brackman kicked off Avery Becker for good?
Yes, I believe that did happen.
And after Avery got kicked off, she texted everyone to get back on the team.
I didn't really see Avery's texts, but I do believe she texted lots of people on the team.
And moving on, you went to the Fresh Shack later that evening.
Correct.
And one of the people you saw was Alex Cifuentes.
Yes.
And moving on, you said Avery was attached to her phone.
I mean, as most teenagers are.
But that's still a yes.
Yes, I did see Avery on her phone on occasions.
And you do not know whether or not Avery left her phone at the Fresh Shack or not.
No, I didn't know if she left it there because I didn't see
and,
it.
But that's still a yes, correct?
Yeah.
And lastly, you're the only one who can testify today in court that Avery was with you the whole day, correct?
She was with me the whole day.
But that's still a yes.
Yes, she was with me the whole day.
Okay, no further questions.
All right, anything further?
Your Honor, I request a really brief redirect.
You may.
Ms. Perkins, are most teens attached to their phones?
Yes, I think it's pretty normal this day.
Objection, speculation. And this is outside the witness's statement.
Response to the objection?
It was mentioned in the cross-examination whether or not Avery was, and as a general part of the population of teenagers, she would have general knowledge on this question.
May I respond?
You may.
As this witness can testify for herself, but no one else rather than herself, as it doesn't state in her witness statement anywhere whether she has the knowledge of knowing if teenagers are attached to their phone or not.
Okay, the scorekeepers can address that issue if they would like, but the objection from a legal perspective is overruled.
All right. Ms. Perkins, would you like me to repeat the question?
That's okay.
You answered it.
All right, moving on. Ms. Perkins, would you say that you were with Avery all day?
Yes, I was with her the entire day.
All right, no further questions.
Okay, very good. All right, further evidence, further witnesses.
Your Honor, we asked to bring Avery Becker to the stand.
All right. You may inquire.
Miss Becker, you are here, a high school student being accused of murder. How do you feel?
There aren't even words to explain how I'm feeling right now. I'm sitting here being accused of something I had nothing to do with. Nothing at all. I'm 18 years old.
Objection, relevance.
Relevance?
Your Honor, this is laying the foundation to why or why not my client committed this crime.
May I respond?
You may.
The then existing feelings currently of the defendant after the crime has been committed does not make a case in the factor more or less likely, as these, whether they be emotions or not, aren't relevant to what happened back then.
Your Honor, may I respond to that?
You may.
She's saying that she's frustrated because she didn't commit this crime, so she's proving why she didn't.
All right.
May I respond?
You may.
Again, this is a present emotion, which would still be considered irrelevant since what we're trying to do is figure out what occurred in the past, which again, then existing emotions won't make anything in the case more or less likely.
All right, I understand the objection and I understand the argument. The court finds that it goes to weight rather than admissibility. Objection is overruled.
Thank you, Your Honor.
Ms. Becker, did you kill Mackenzie Brackman?
No, I can't even imagine doing such a thing. This is a mock trial team we're talking about. We got into a few arguments, but I would never kill him because of it, ever.
Did you and your coach get along?
On some occasions, yes, but we did butt heads. He would call me lazy and thought I didn't put in enough work. And I think deep down, he was always jealous of this natural ability I have for mock trial because he was an average lawyer. He put in a lot of work in what he did. And I think he took it out on me. But you know, in the end, he always gave me the best roles and the roles that were the hardest because he knew I could handle it. He knew I could win it for the team.
Objection, narrative.
Response to the narrative objection?
Your Honor, we can move on. We're done with that question.
All right.
Ms. Becker, do you have a lot of friends on the mock trial team?
Well, my best friend Taylor is on the team with me, and I'd say I'm pretty good friends with everyone else except for this kid, Alex Cifuentes, whom I despise. I do not like him at all. He puts a lot of work into mock trial, and he's always been jealous of my natural ability.
Ms. Becker, why did you get demoted to B team before the regional tournament?
Well, like I said, Coach Brackman would get angry with me on occasion. I think he had finally had enough of my lack of work, and he kicked me off the team and demoted me to B team.
And Miss Becker, why did you get put back onto the A team?
Well, my friend Taylor offered to step down. She knew it was important to me, and she didn't like mock trial all that much, and she did it for the sake of the team because
Objection, speculation.
Response?
Your Honor, she does have the foundation for this. Taylor is her best friend, and she observed the relationship because she's part of the relationship.
May I respond?
You may.
This still would qualify under speculation, as currently the defendant is testifying to exactly what their friend had stated. And despite them would obviously knowing the good relationship between the two, the defendant cannot testify as to why it occurred.
Your Honor, may I respond?
May.
She's not saying exactly why it occurred. She's doing what she believed, and she does have the correct foundation for this because Avery is her best friend.
An objection sustained. Next question.
Did you do well at the regional tournament?
I did. I won both best attorney and best closer.
And did your coach celebrate that victory?
No. In fact, he called me out in front of everyone, and it was a little embarrassing, and he didn't even congratulate me.
And what was your response to his criticism?
I didn't respond well. I don't normally let his criticism get to me, but this time, unfortunately, it did, and I reacted rashly.
And did you vandalize Mr. Brackman's car?
Objection, leading.
Response?
This isn't leading. This is a yes or no question that she can answer with her own response.
May I respond?
No, it is leading, sustained. Next question, you may rephrase.
Miss Becker, what did you do what was your response to Mr. Brackman's criticism?
Well, I stormed out of practice, and I was so angry, and I looked at his flashy Porsche, and I couldn't even, it tipped me over the edge, and I had a marker in my hand, and I thought it was dry erase, and I drew on the hood of his car worst attorney award, and I regretted it immediately after.
And what did Coach Brackman do when he saw his car?
He was mad, rightfully so, and he kicked me off the team right then and there.
Was that your last encounter with Mr. Brackman?
Unfortunately, yes. I called him, emailed him, texted him, told him I would get a job, and
Objection,
the car.
hearsay.
Response to the hearsay objection.
Your Honor, this is a statement made outside of court by the defendant. Hearsay doesn't apply to that.
Very well.
May I respond?
No, it's the objection's overruled. It's her statement. She's not telling me what he said, just what she said. Next question.
And so was that your last encounter with Mr. Brackman?
Yeah, I never saw or heard from him again.
Miss Becker, what were you doing the day of the murder?
I woke up and I couldn't find my phone anywhere, and I decided to skip school since there was nothing really important going on. And Taylor and I went to go retrace our steps from the night before and look for my phone.
And were you with Miss Perkins the entire day?
Yes, I was.
And why didn't you notice your phone was missing before?
Well, every night my mom takes my phone before I go to bed, and so I just thought it was with her, and I didn't realize it until I went to go get it the next morning.
Mr. Cifuentes claims there are text messages between him and you. Did you send any text messages to him?
No, I can't stand Alex Cifuentes. I don't know. I would never, ever turn to Alex for anything, let alone this, ever. I did not send those.
Ms. Becker, why do you think you're being accused of murder?
I think these fights that I had with my coach are being blown way out of proportion. We're talking about mock trial, my high school mock trial team, and a murder. And I would never kill someone because of mock trial. I can't believe any sane person would think I would even do that. I and Alex, he's always been jealous of me and my abilities, and this is his one shot, and he is so dedicated to mock trial that he would do something like this.
Ms. Becker, finally, should you be convicted of murder?
No, I didn't do it. I don't even know where Coach Brackman lives. I didn't commit this murder, and I hope everyone in this room knows that, because I had nothing to do with it. I lost my phone and I was looking for it, and now I'm sitting here and I didn't do it. I didn't.
Thank you, Your Honor. No further questions.
Counsel, cross-examination?
Yes, Your Honor. I'd first like to start by talking about your perspective of the case. You believe yourself to be wrongly accused, correct?
Yeah.
Excuse me? Your Honor?
Yes?
So we have a time discrepancy of, I don't know what the B team timekeeper has, but I paused for some of the impeachment section because she had some technical difficulties looking through things. And this leaves us at like a time discrepancy of about 48 seconds, I think. I don't, that was last time we checked at the end of the last cross, but.
What do you have now? Is it still 48 seconds?
The B team has 4 minutes left for cross. I have 5 minutes, 30 seconds. It somehow got larger. I don't really know what's going on, but
Could
all
there
right.
Could there be I forgot what it's called, but like
We've had a lot of objections, and I'm assuming that we probably lost some time in there.
mhm.
Hang on here. I'm looking at the rule right now, so just give me just a second. All right, it says the presiding judge will rule on any time discrepancy before the trial continues. Timekeepers will synchronize their stopwatches to match my ruling. Do the timekeepers have anything they want to bring to my attention that's going to give me a basis for deciding one way or the other?
I'm not a timekeeper, but to offer a compromise to the time discrepancy, would 4 minutes and 30 seconds be a fair amount of time to utilize?
Any objection from the opposing side to proceeding in that fashion?
Your Honor.
I'm sorry, I didn't get first that. No objection?
No objection.
Okay, let's have everybody synchronize their stopwatches at 4 minutes and 30 seconds. And Mr. Walker, you may resume as soon as the timekeepers tell us they're ready.
Thank you, Your Honor.
Timekeepers, just give us a heads up somehow.
I'm ready, Your Honor.
All right, I'm going
to proceed.
I would first like to talk about your perspective of the case at hand. You believe yourself to be wrongly accused, correct?
Yes.
And you also believe the text mentioned during direct to be fabricated, correct?
I didn't send those.
Despite this, you don't offer any form of evidence that, such as your phone, to prove that those texts are in fact not sent by you.
Neither did Alex.
However, Alex did provide the screenshots, correct?
Yeah, that's on his physical phone though.
I would now like to move on to your relationship with Mackenzie Brackman. You and Brackman got on each other's case, correct?
Sometimes.
You and Brackman have argued before, correct?
Yeah.
You even believe the late Mackenzie Brackman hated you, correct?
hate is a strong word, but
However, it is the word you mention in your affidavit, correct?
yeah, he hated me.
And you even hated Mackenzie Breckman in return, correct?
I didn't love him.
However, you used the word hate in your affidavit, correct?
Correct.
I would now like to move on to the day you committed vandalism on the late Brackman's car. That day, mentioned in direct, you got frustrated with Brackman and committed the crime of vandalism. This was because you were upset, correct?
I thought the marker would come off, and I regret it.
However, in that current state of mind, you were upset and committed a crime out of anger, correct?
Yeah, I was upset, but I regretted it.
Thank you. I would now like to move on to the date of March 6, 2020. That day, you were not present at school, correct?
No, I was looking for my phone.
And however, the only person who can attest to this, other besides yourself, is a close friend of yours, correct?
Yeah.
A close friend of yours that had done an action to benefit you, that action being dropping out of A team so you could be on A team, correct?
On speculation.
May I respond?
You may.
Your Honor, this is not speculation, as it was something already addressed in direct, as well as it had been resulting in the promotion of the defendant.
May I respond?
May.
She doesn't know exactly why or why not Ms. Perkins stepped down, and the question asked her to assume her position.
May I respond?
Briefly.
The defense has already established the good relationship between Taylor as well as Avery, which would fall under the scope of examining and determining the relationship between the two.
We're going to be cumulative. Sustained. Next question.
Thank you. No further questions, Your Honor.
Redirect.
Ms. Becker, did you send the text messages to Mr. Cifuentes?
Objection asked and answered.
Response.
This is a redirect. I can re-ask a question to clarify something that happened during the cross.
For clarification, go ahead.
Ms. Becker, did you send text messages to Mr. Cifuentes?
No.
Thank you. Oh, and were you with Ms. Perkins the entire day of the murder?
Yes.
Thank you, Your Honor. No further questions.
Okay, very good. See, I think that concludes the evidence, correct? Is the prosecution ready to proceed to their closing argument?
Yes, Your Honor. Before I start, I ask that that the timekeeper counts down in 30 seconds, if that's okay.
Your timekeeper, you can still do whatever you ask her to do, I'm sure. Okay.
And then any remaining time left for rebuttal.
You may keep it.
May I begin?
Please proceed.
How far will you go to get revenge? Would you vandalize someone's car? Would you break into someone's house? Would you go as far as to murder someone? On March 6, 2020, Mackenzie Brackman, a beloved coach of the Colorado High School mock trial team, as well as a talented litigator, was brutally murdered by the defendant Avery Becker. Not only was Brackman murdered, but his residency was unlawfully, feloniously, and knowingly broken into by the defendant. Now, ladies and gentlemen of the jury, today you are here to prove that the defendant Avery Becker murdered Brackman in first-degree murder, and you are here to prove Avery Becker guilty with second-degree burglary and criminal mischief. Today, you heard from three incredibly useful witnesses in which their testimonies today crafted the indisputable evidence in which Avery Becker had committed the crime. Alex Cifuentes proved that Avery Becker had the intent of breaking in and damaging Mackenzie Brackman's home. They told us today Avery always showed up late to meetings, always unprepared, always being called out by Mr. Brackman. Avery was even then demoted to the B team due to their actions. They grew very upset, and in permanent marker, they wrote "Worst Attorney Award" across the hood of Brackman's car. They even said themselves that they were willing to do whatever it took to get back at Brackman. Now, if that's not enough proof, the defendant then texted Alex Cifuentes stating that they would go into the house and trash it. Next, you heard from Kyle Cusack, who proved to have 19 years of experience investigating complex crime scenes, which include home invasions, burglaries, and other property crimes. Kyle Cusack walked us through a crime scene and what steps she used to come up with her conclusions. Kyle Cusack not only justifies the conclusions she came up with, but they also explain how the defendant entered the house, the struggle between the defendant and the victim, and finally the murder of Mackenzie Brackman. After that, you heard from Detective Jordan Markowitz, qualified in detective work and cellular technology, solidifying the evidence given. She has 13 years of experience being part of the Denver Police Department, 7 of those being a detective. Markowitz was not only able to utilize cell phone towers to pinpoint Avery Becker's phone heading towards Brackman's house around the same time of the murder, but was also able to utilize a detective skills to determine the struggle between the two. Then you heard from the defense. Members of the jury, I ask you to reject the defense's theories of the case. You first heard from Taylor Perkins, one of Avery's best friends. Not only did Taylor admit that Avery always came unprepared to mock trial meetings, but Taylor also admitted that Avery had an incredibly inflated ego. Now, you may say Taylor said that Avery and her were together the whole day, but in reality, there's absolutely no substantial evidence that backs up the theory. In reality, it is only a theory. Today in court, Taylor is the only one who can testify on behalf of Avery and has every reason to lie to you. Taylor would have everything to lose if Avery Becker was to be found guilty. Next, you heard from Professor Blake Van Owen. Today, she has proved to have so much bias. First, she's only testified in court on behalf of the defense, and even then, she expects to be paid between $6,000 to $10,000 per one case. Professor Blake Van Owen was never actually on the crime scene, and today in trial, Blake Van Owen was not only once impeached, but twice. This witness not only has bias, but is not credible. Lastly, you heard from the defendants themselves. She admitted that she vandalized the coach's car. She admitted she was frustrated. She admitted that she even hated Brackman. They admitted they were angry, willing to do whatever it took to get back at Brackman. In the end, she proved the prosecution's theory of knew it, wrote it, and did it. The prosecution understands that the burden of proof falls upon us, and ladies and gentlemen of the jury, today we have proved it without a reasonable doubt. You must find the defendant guilty in first-degree murder, second-degree burglary of dwelling, and criminal mischief. Thank you.
Sorry, my mute button wasn't working. Is the defense ready to proceed with their closing argument?
Yes, Your Honor.
All right, you may proceed.
Avery Becker, a high school student, sits in front of you today on trial for a crime she did not commit. She sits in front of you here today being accused for the murder of her coach, a person she saw every single day for weeks at a time for 4 years straight, a person she was extremely close with. She is 18 years old. Did she commit this crime? No, she did not. She has a clear alibi. She was with her friend Taylor Perkins the entire day, retracing her steps through the fry shack and the mall trying to find her phone. Avery Becker was obviously not near Mr. Brackman's house during the murder. Now, ladies and gentlemen of the jury, you heard the prosecution. They claim there was a struggle between Mr. Brackman and the intruder. With what evidence? A couple of scuff marks that cannot be dated, scuff marks that could have been made at any day or any given time, or perhaps a broken plate. A single broken plate was the only thing out of place at Coach Brackman's house when there was a struggle. Now, if the struggle between the intruder and Mr. Brackman was so great, where is all the blood? Wouldn't you expect blood splatter to be all over? How could there be a struggle with just a few marks of it? The prosecution's theory is flawed yet again with the Ring security camera. The prosecution believes a video of someone with the generic build of Avery Becker is enough to convict her, when Avery Becker is of average height, and there are so many other suspects that could fit that physical description. What about the forensic evidence? Are there any footprints? Are there any fingerprints? There is nothing specific at all that connects Avery Becker to this murder. There is disagreement between trained professionals as to what happened, a total lack of information. An expert witness says the murder was premeditated, not an accident. Evidence shows the knife used to kill Mr. Brackman was an entirely different brand than those at Brackman's house. This murder was premeditated. How can we accept the prosecution's theories when there is proof something else occurred? The evidence the prosecution presented doesn't prove this was a burglary gone wrong. The evidence the prosecution presented doesn't prove Avery Becker is guilty. There is reasonable doubt everywhere. Detective Markowitz claimed that he didn't actually have the expertise to prove what the crime scene meant. Detective Markowitz stated that a cell phone connects with the best available tower, not the closest. This is not evidence. This is a theory that can be doubted. The evidence witnesses have brought forth are contradicting. There is so much gray area. So why is a high school student being put on trial? Is it because it's the most convenient for the prosecution? They tried to string along a theory they came to by cutting corners in this investigation. They didn't follow through with all possible leads. The prosecution cut corners in their responsibilities, and Avery Becker was a result of their lack of procedure. So why is Avery Becker's innocence still being questioned when she has a clear alibi? When experts disagree over what exactly occurred the night of the death? When the prosecution failed to present any significant evidence? Is the jury going to sit here and allow an innocent person go to jail for a crime she did not commit? An accusation that has not been proven beyond reasonable doubt. A sentence that will change the course of her life forever. An accusation that is not fair because there's too much speculation, all they have is theories, and there's too much evidence that supports her innocence. This was her coach for 4 years. A small disagreement doesn't lead to something like this. Ladies and gentlemen of the jury, it comes down to this. The prosecution has not proven their case. Avery Becker is innocent.
Thank you. I think the prosecution has a little bit of time left.
May I request how much time I have?
This is 1 minute and 8 seconds.
All right. Today I ask you to remember, knew it, wrote it, and did it. When putting all the evidence together, it all adds up without a reasonable doubt to Avery Becker. So today, members of the jury, I ask you to find Avery Becker guilty with first-degree murder, second-degree burglary of dwelling, and criminal mischief. Thank you.
All right, thank you all. That concludes the trial. The scorekeepers need to get busy and do their scoring. And the rest of you, if we can just hang out for a minute. I see that our moderator is coming on board. Maybe she can provide us with some more guidance.
At this point in time, if the scorekeepers are putting in their scores, if you wanted to give any general comments, Your Honor, you may do that. Once I have the scorekeepers' scores in, I will let you know, and then we can stop the live stream at that point in time, okay?
We can have an opportunity for the scorekeepers to
They will, as soon as they get their scores in. Yes, they can do that. And if we could have all of the students turn on their screens at this point in time, so that way we can see your faces and give you the comments that you deserve.
All right, so our scorekeepers need to kind of ignore us while we chat over here. Normally I have you sit over in the back of the jury box and get your scoring done, and I come down off the bench and chat with the students, but we really can't do that today. I guess the first question that I have for the students is, what do you guys think of this this storyline with this problem? I think it was right in your wheelhouse. You can all, if you want to turn your microphones off when you are commenting, that's great too. I mean, I know that you've all worked very hard over the last year or so just to get where you are today. How many of you have done mock trial before? Who's done it at least once before? Just one, two, three, just a couple of. So several of you, this is your first time? Well, wonderful. How many of for you, this is your third year? Three? Okay, 3, 4, 5. Okay, good, good. How many of those that have been doing it for a couple of years want to go to law school? Not a single hand goes up. That's I don't blame you. It's a tough job, right? Yeah, it's hard, especially when you're standing up there. You've now done it 3 times in this competition, and those of you who've done it before had an opportunity to do it in court. I'd like to have your thoughts. Those of you who've done it a couple of times in court and on Zoom now, turn your microphone off and give me a little bit of thoughts on what you think is the most challenging thing of doing it by Zoom as opposed to standing up in a court like the one behind me.
I think there's like a lot of, I guess there comes a lot of issues that you don't normally face, like technical difficulties and like stuff like that. However, overall, I feel like being online allowed for a confidence boost, and at least some people like me, because you're not physically in front of a lot of people, so it's easier to talk.
So when you're only seeing the witness and perhaps me and maybe opposing counsel, it's easier than if you've got a jury sitting over there and parents and coaches sitting behind you and all of that?
Oh, for sure. Like, I don't know how well I would have done like in any of these without Zoom, because it just felt a lot more one-on-one or like just me doing stuff, which really helped out.
Anybody else want to weigh in on that?
Yeah, same here. I agree with Marcus on having a confidence boost over Zoom versus in real life, because in real life, it's a lot more nerve-wracking to have every single person staring at you and you can tell they're staring at you. Whereas over Zoom, when you're just looking at the judge and the attorney and the opposing team's attorney, you don't really have to, even if everyone's looking at you, you don't know, and it's a lot easier to have your mind straight.
Mm-hmm. Well, I've done about half a dozen trials over Zoom, both regular trials and arbitrations. And I'll tell you, the lawyers, and these have been some very experienced lawyers, struggled a lot more than you folks did. I know you've practiced probably a lot more than they did. In fact, I know that you have. But they struggled a lot, especially with the screen sharing. You folks had that down almost to a science. That went very, very smoothly compared to what happens in real life. I think probably part of that, though, is that these lawyers are all, not all of them, but the ones that struggled with it are probably not as tech savvy as you are. And, there's a little bit of coordination between hitting the share screen button and making sure you've got the right picture up there. How many of you, I know you probably talked about this before and you all probably laughed about it, but how many of you saw that video of the attorney who had the cat face on his thing? And that has got to be an attorney's worst nightmare. But to his credit, he basically said, look, I don't know how to fix it, but I'm ready to proceed, Your Honor. And he was going to proceed arguing as a cat. And I thought that takes a lot of cool. How does this compare with some of the things you're doing in school when the classes that you're doing online?
This is fairly similar. I'm in the extracurricular speech and debate. So I must say I am more like experienced with the debating style because I do other kinds of debate. but it is fairly similar. There's a screen of people and you're discussing a major topic and you have the person that's talking you're focused on, and usually people's screens are off while you're in a classroom.
And it's just the teacher up there. Okay. Anybody else want to weigh in on this whole technological problems that we're facing these days?
Not trying to throw shade at any of my other classmates, but no one else talks. It's just me, so I'm used to it at this point.
You're the guy that talks a lot. Okay. All right. Well, I guess as a general concept, I don't want to say too much because I don't want to influence what the scorekeepers are
We
saying.
do have all the scorekeepers' scores in, Your Honor, so you
They're all
can
in?
say what you would like to say at this point in time.
Great. Great. Well, I think you all did great, but I want to give them an opportunity to talk to you. I thought everybody was very well poised. I thought that there were a couple of times, especially in that last part of the trial, where there was a lot of back and forth between the lawyers on some of the objections, and you had to struggle a little bit with where you were going. And I thought you all handled that very, very well. Who wants to start? Adam, you want to start?
Yes, Your Honor, thanks. First of all, great job to everybody. Good throughout this round, more than I've seen in other rounds. I thought the language choices were better, whether it was an attention grabbing thing or something to get more specific on testimony from all players. I thought that was great. Kind of something the judge talked about. I was very impressed with everybody's poise and professionalism. When there's that back and forth, I'll admit I get there. We get competitive and we want to get that answer that we're going for. But realize in this, it's the professional is important, and then in real life, a jury's going to understand what you're going after, and so that poise of knowing kind of when to stop when there's a back and forth, when to enough happened here. I'm not going to get exactly what I want, but take what they've given you and work with that. I was going to call out Caitlin, especially for your conduct in that. It was very well done. So that no one went to stop, and that discretion is huge, and it's going to transfer to a lot of areas. Lastly, with the Zoom format and then just being more confident, realize to everybody here, there are a lot of skills transfer between this and then whether it's in a courtroom or whether it's in any other arena, that you should hopefully recognize some well-earned confidence, because it's all about getting reps, putting yourself out there a little bit. Not always going to be perfect, but everyone here I thought did a great job and should be more confident in how you present yourself, because you're making it happen even in this difficult format and you're doing it well. So thanks a lot.
Great. Okay, Charles?
Oh, yeah. I had a great time. This was a good round. There were several people in here that, well, all of them were very good. They know their parts. I thought one thing I want to say, Mr. Walker, I really liked how you stepped up regarding the time discrepancy. Somebody's got to make the decision. You stepped up and put out a number, and that's what it takes sometimes. Miss Mahoney, Miss Adams, and Miss Mon, that interplay between the three of you in that section of testimony was wonderful. Really good. It was fun. And Miss Fitzpatrick, you were very, very, very good. I really liked your closing, and I liked your work as an attorney. So, but all of you were very, what I liked about this round so far is I saw everybody knew their part. You all knew your part. Another statement, Ms. Calkins, you were a great witness. You did a fine job. This is not real law, as I had to learn over, I think, 6 years of doing this. And the first time I did it, I wanted somebody to be guilty or innocent. Now I'm finally, well into understanding that this is a performance. And I've seen some good performances today. And Ms. Calkins, I thought your performance was really very good. That's it.
All right, great. Tripp?
Wow, Charles took a lot of my talking points, like pretty much everything I wrote down he said, but I just want to echo again the the way that you guys adapted to doing Zoom is amazing. I've also seen a lot of Zoom depositions, hearings, and you guys have adapted a lot better than some of the attorneys I've seen. So it was very impressive. And I think this format suited all of you well. I gave very high professionalism points. I mean, it was just professional all around. I was especially impressed with how well that you guys dealt with the timing discrepancy. That was just smooth, and you guys came to a resolution so that the judge didn't have to weigh in, and that was impressive. And I mean, honestly, Mr. Walker, I don't think you needed the extra time. So you did the right thing by saying, yeah, 4.5 minutes is fine, because I thought your cross-examination after that was effective. And I mean, it probably would have just been, going on longer than it needed to if you had an extra minute. So it was the right move. And I also, like Charles, thought the voir dire of Van Owen was very effective, and also the counter arguments to the objection to qualifying him as an expert. That was clearly well prepared. You had the rules down. So, I mean, the openings and closings were also very concise, had a theory of the case that I could follow. And I especially liked on the defense's closing how she stood up. I thought that was good, because it, kind of reminded me of the courtroom. And so, yeah, very good, everyone. Great performances. The witnesses were also very believable.
Yeah, I think everybody did a really wonderful job. They all got into their roles really well, and I was very impressed. I think I said this before, but I want to emphasize this, that you were all able to think on your feet. At this stage, everybody's got their texts down. They know what they want to say, but when you get a little bit of a curveball, that's where it's really important. And I think that's what all three of the scorekeepers were saying, is that you all handled those curveballs from the objections and from the other things that happened very, very well. This is the point where I used to say, everybody stand up, turn around, and look everybody in the back of the courtroom and thank them, because it's not just you all that really worked hard. And I know that your parents and coaches and everybody are watching on the live screen. So I want to personally thank them all. And I want you all to thank them when you see them, because they've sacrificed as well. They are the ones who made sure that you had the time and the energy and the encouragement to do this. And they're also the ones that apparently have given up a lot of their houses for this morning and probably yesterday and today to let you all set your Zoom up and take part of the Saturdays. So be sure to thank them all, because they've done an outstanding job as well. All right, back to the moderator. What do we do from here?
At this point in time, we have everybody's scores in. So I'm going to go ahead and stop the live stream at this point in time. Be prepared go get prepared for your next round, and good luck. All right.
See the good judge standing at the door behind you, wanting you to. Now he's walking away since I called him out.
Yeah, you called him out.
All right.
Thank you, guys.
Thank you all, and congratulations, everybody, and good luck in the final round.
Thank you to everyone who judged.
Bye. Congratulations, everyone.